state-based insurance regulatory system. Historically, the insurance industry in the United States was regulated almost exclusively by individual state government. The first state commissioner of insurance was appointed in New Hampshire in 1851, and the state-based insurance regulatory system grew as quickly as the insurance industry itself. Prior to the period, insurance was primarily regulated by corporate charters, state statutory law, and de facto regulation by the court in judicial decision. Under the state-based insurance regulation system, each state operate independently to regulate their own insurance markets, typically though as a state department of insurance of division of insurance, strongly back as far as the Paul Vigialana cases in 1869. Challenges to the state-based insurance regulatory system have arisen from various groups, both within and without the insurance industry. The state regulatory system has been described as cumbersome, redundant, confusing, and costly. The United States Supreme Court found in the 1944 Causes of United States v. Southeastern Underwriter Association that the business of insurance was subject to federal regulation under the Commerce Clause of USA Constitution. The United States Congress, however, responded almost immediately with the M.C. Karen Ferguson Act in 1945. The M.C. Karen Ferguson Act especially provides that the resolution of the business of insurance by the state government is in the public interest. Further, the Act states that no federal law should be consulted to invalidate, impair, or supersede any law enacted by any state government for the purpose of regulating the business of insurance, unless the federal law especially relates to the business of insurance. A wave of insurance company insolvencies in 1980s expects to renewed interest in federal insurance regulation, including new legislation for a dual state and federal system of insurance solvency resolution. In response, the National Association of Insurance Commissioners adopted several modern reforms for state insurance regulation, including risk-based capital requirement, financial resolution, accreditation standard, and the initiative to codify accounting principles. As more and more states enacted various of these model reforms into law, the process for federal reform of insurance regulation wanted. However, there are still significant difference between states in their system of insurance regulation, and the cost of companies with those systems is ultimately borne by insureds in the form of higher premiums. McKinsey and companies estimated in 2019 that the US insurance industry incurs about 30 billion annually the unnecessary regulatory cost under the state-based regulatory system. The NAIC acts as a forum for the creation of model laws and regulation. Each state decided whether to pass each NAIC model law of regulation, and each state may make changes in the enactment process, but the models are widely, albeit somewhat irregularly adopted. The NAIC also acts the national level of advanced law and politics supported by state insurance regulators. NAIC Model Act and regulation provided some degrees of anonymity between states, but these models do not have the force of law and have no effect unless they are adopted by a state. They are, however, used as guides by most states, and some states adopt them with little or no sense. There is a long-running debate within and among states over the importance of government regulation of insurance, which is noticeable of the different title of their state insurance regulatory agency. In many states, insurance is regulated through a cabinet level department because it economic important. In order, state insurance is regulated through a division of a large department of business regulation or financial service, on the grounds that elevating to many government agencies to department leads to administrative chaos, and the better option is to maintain a clear claim of command.
you.